We are on to the IPOB lead counsel, Sir I.C. Ejiofor Esquire. We want to know from him what transpired today in court. Please, Ifeanyi Ejiofor Esquire, kindly proceed to telling us what happened in court today.
Okay, thank you so much. Actually, the matter came up today for ruling on application to vacate the order revoking the bail of Mazi Nnamdi Kanu. Order was made on 28th day of March 2019. So, and also to vacate the bench warrant issued portion to that order. Because this application that was ruled upon today became necessary to be heard when, in the course of the ruling, the court delivered a last adjourned date on application for bail. The court now said that, observing the course of the ruling, that application for bail is premature at this point in time, but he's not conclusively denying him bail, but he wants to, at this point, to inquire into what led to his disappearance from court since 2017 till he was brought back to the court on 27th of June 2021. So that was when we reminded the court that we have an application we filed on the 1st day of April 2019, which contain details of what happened in the home of Mazi Nnamdi Kanu on the 14th of September 2019, when the military invaded the premises and killed over 20 persons in the premises, all in a bid to assassinate or eliminate Nnamdi Kanu, but he narrowly escaped by whisker. So, and more so is the fact that this application we're talking about has been in the court file since this April 1st, 2019. And that application also contained detailed accounts as given by Mazi Nnamdi Kanu. Only Mazi Nnamdi Kanu deposed affidavit of facts, which were all verified on oath when he was in state of Israel, giving detailed account of how his house was invaded on 14th of September 2019, how people were killed, how his home was destroyed, how he narrowly escaped being killed by mere act of providence. So the court now asks us to proceed to move the application. That was the last adjourned date. Even the prosecutor, it's important for me to highlight this fact because I'm making a foundation for issue I want to resolve, which came up during the ruling court delivered today. The prosecutor could not even lay hands on this application, even the one they filed. They couldn't even find it in their file at last adjourned date. So we have to oblige them the copies in our file, including the copies who filed and also their response, the counter affidavit they filed in response to that application. So, and when court, which took almost 15-20 minutes to be concluded, this exercise. So when court was satisfied that this application has been in his court file since April 1st, 2019, and this application in substance has taken care of actually what the court's requesting us to do. So, and here, there, and then Nnamdi Kanu, when Mazi Nnamdi Kanu was in court, the court asked us to move the application. Because the essence of this application is to explain to the court. The court said it hasn't been formally informed, despite the fact that this application has been in the court file. And each time, at any given time, the matter was coming up then, we bring to the attention of the court that this application will have it before you. Because they've been talking about jumping bail and other things which should be resolved by the content of this application, particularly the affidavit on oath verified by Mazi Nnamdi Kanu. So it was taken and adjourned for ruling. The day it was adjourned for ruling, the court sent a message across that his lordship will be disposed. So obviously on held ground, I will not be able to call on it to sit. So I was consequently adjourned out of record to today for ruling. So today, the court ruled on it. Unfortunately, the application was not granted. The court, part of the grounds upon which the application was refused, according to his lordship ruling, was that first of all, there was no breach of fair hearing because and no breach of fair hearing because we are complaining about not giving us time not giving the defendants time to address him on things, on facts of what happened in his house, opportunity as contenders without the file of the Constitution. So, and also that it took us 4 years to file this application. It costed it in open court. So, however, it's also important for me to digress a bit because we have to explain things in a manner that people understand it in black and white. It's here. I will even oblige you copies of what to file on the 1st of April. It's here. It's not in Lagos. It's here. It was a decision the court made on 28th of March 2019. And on that day, because on that day, before 28th of March 2019, a matter came up on 11th November 2018, when the court invited the sureties to come and explain the whereabouts of Mazi Nnamdi Kanu. I actually filed a process in court. The court said, therefore, I will not listen to this process. I have no business with you. I don't want to talk to you about your client. I want those who took Mazi Nnamdi Kanu bail to come and produce him before the court, because I gave him to them. So they were in court on the 11th of November 2018, selected by his lordship, and they all filed processes before this court. Distinguished Senator to file a process, Tojuku filed a process, and the third person filed a process, explaining to the court what happened to the person they took on bail. That this person was due to be in court on 11th of October 2017 to conclude to trial. But instead of the federal government waiting for him to be in court, the military went to his premises, to his home on 14th of September to kill him. Also stating the fact that he assuming without considering to the fact that he committed any offense, in the course of enjoying the bail granted to him by court, that they were being asked to produce him before the court, or probably so that on that day he's coming to court, the court probably will frame for Rapture an account of the offenses committed. But without reference to them, the military went to his premises, killed, and in an attempt to kill him, they don't know whether he's alive or dead at the point we are talking about. So this application were all filed before the court. Before that, 11th of November 2018. So they were in court on that day with this application. And the court said, okay, they told the court, the lawyers informed the court that we have an application before you, stating the fact that the person who gave us on bail, we can no longer lay hands on him. We don't know where he is. We understand his house was invaded. We don't know whether he's alive or dead. Why would he be attacked? As a matter of fact, we want to relinquish our tradition. This was contained in the document they filed in court. The court now said, okay, we are going to hear this application on 28th day of March 2019. We filed. So, but for interim, the court proceeded to rule. The sureties on that day they were in court, without listening to them, without hearing the application they filed in court. The judge proceeded to rule as follows: that the sureties have still not produced the defendant. In interim, the court hereby ordered that the sureties in interim should deposit the bail bond in court within 2 months from today, for 6 months, or the bail will be forfeited. The motion pending will be heard on the 28th day of March 2028. Now, somebody was invited to come to court and explain to the court the whereabouts of the person you took on bail. And the person came to court formally and with the application, an affidavit of facts, documents, exhibiting video evidence, documents and pictures showing that showing what happened to the person they gave him on bail. They are before you. The court wouldn't have made this ruling without hearing that application. The court was waiting for the application to be heard on 28th of March before giving ruling one way or the other as to what to be done for action. So ruling has probably untwisted the people you invited to be in court. Now they want to come appeal and file appeal against this ruling delivered on 28th of on the 14th of November 2018. They file appeal, and the matter was adjourned to 28 for the hearing of this application. So on that 28, they informed the court that they were going to appeal against the ruling order he made on 14th of November 2018, and the appeal has been entered. And as such, they also have a motion for stay before the court. And as such, the court will not proceed to hear this application because the application the court sought to hear has been overtaken by men, by another court rule made, has been tampered with by another court made. So, and the courts, it's okay, no problem. I will join this matter, sine die. This happened in open court, in black and white, recorded. Then we were in court on that 28th day of March 2019 for court to hear this application because court said, I don't have their time now. And the matter wasn't adjourned for trial. It was adjourned for the hearing of application filed by the shorty. So, and immediately the court was informed of the fact that the appeal has been entered on another order he made, against the order he made. The court directed, and the court now adjourned the matter sine die. Then when the matter was adjourned sine die, the shorties left the court. The shorties immediately left the court premises. Then remaining me and except me and the prosecutor. Right? So now, what the fundamental thing that took place on this 28th day of March 2019 was that immediately the shorties, the lawyers or president shorties left the court premises. The court beckoned on me to produce my client on that day. Say, Geoffrey, where is the client? Let him enter the witness box. We are going to commence trial now. This is what happened in court. I said, my lord, the matter was coming up for hearing of this application. You never asked us to produce our client on this day. You never even asked me to make any representation to the court as to whereabouts of my client. The court proceeded therein without listening to us, without either formally or orally. The court proceeded to revoke his bail, and here and there granted bench warrant, issued bench warrant against our client. So now the law is right that when an application order of such is made without giving you opportunity to be heard, you have the right to come back to the same court that made the order and urge the court to set aside the order he made without judicial. So that was what prompted this application was filed on the 1st day of April 2019, asking the court to vacate that order he made, issuing bench warrant against our client and revoking his bail. So this application has been in court file since this date. See it here. I'll give it to you. Because some people go out and misrepresent the fact to the public that this application was just filed this year. This is 2019 application was filed and was taken as last urgent date. Matter came up. So today the court said it took us 4 years to file this application. You have a copy of this. I'll show it to you. Look at it here. It's written. This is court file. It's the original copy. You see the court file. See the file. First day of April 2019. You can see it. It's the original copy filed in court to see it. Then I will make photocopies of it and give us everything. So, however, we also recall that when our client Mazi Nnamdi Kanu was abducted in Kenya on 19th of June 2021, and consequently extraordinary relation to Nigeria on 26th of June and brought to this court before this one on 27th. Portion to which the federal government took him to court with reference to us. Afterwards, subsequent proceedings, they filed amended 7-count amended charge and raised objection to the competence of the charge and also usually the court to hear the charge. In view of the fact there was a gross violation of extant international law and domestic laws in the extraordinary relation, abduction and of Nnamdi Kanu to Nigeria. But there are protocol, there are procedure through which a subject, of whatever you call it, will be arrested in a foreign land and brought to this country. He hasn't passed through that process. And it's a very fundamental violation of international laws. So now, another issue to raise now in our objection challenging the competence of the charge. When the application was adjourned for hearing, 24 hours before the date it was adjourned for hearing, they amended that charge to 15-count charge and served us 24 hours before the court. It took us almost from that point to receive that amended charge to about 3 a.m. to work closely with the Chief Michael Zekomese, Europe of Law. So we worked from that time to about 3 a.m. in the morning and concluded on another objections way.
We are on to the.
I granted him bail, and we took him on pretrial conference before then, and he was ready to be in court. And one of the meetings he had with some people, he made it known to the public that he's coming to court on the 11th of October with over 1 million persons, supporters, to come to court with him. I can say this, and I can beat my head, I can swear with my life that only Mazi Nnamdi Kanu were prepared to come to court on October 2017 before this thing happened. I can swear, bet my life for that. Because I took him on pretrial conference. We are ready for the matter, because we know they have no charge against him. They have no case against him. So why did you take war to his house? Even the law allows you. The stand laws allows you to arrest him upon being in court on that day. If you wanted him to be alive, you are waiting for him to come to court. And upon conclusion of his case, you arrest him. And probably prefer for a charge against him. It's allowed. Why going to his service to kill him? So we're talking about this because he's alive today. So this matter should be treated with a wave of hands or levity. So we're not comfortable with the way and manner or the weight attached to what we file in court per se. Because from the middle of the court, obviously the court look at what's before her today. Obviously, he didn't mention the fact that the evidence before her, this evidence reposed to Nnamdi Kanu. Let me show it to you because it's important for you to be on the know about what happened. This evidence of file reposed to Nnamdi Kanu. See it. State of Israel. See it. He reposted this affidavit when he was in the state of Israel. Before the Republic. Stating clearly what happened in his house. So these are compelling documents. The court will look at it and make definite findings on them. But it wasn't mentioned today. Usually. So you see, we are talking about life, fairness and equity and justice. So where is the justice? So I can assure you we are more comfortable going to court of appeal. Don't see it as you are playing with time. No. They are not serious about the trial. So let us go to court of appeal and solve the remaining thing. We won't be coming here every day and be taking adjournment. Of course, already. Assuming we are not in court of appeal today, the matter will not go on to, of course, you know. They will adjourn the matter after vacation, probably sometime in September or November or October. We'll come back on October, then something will happen again. They'll adjourn to next year March. So take it seriously. They'll adjourn to next year March. And from next year March, they'll say, okay, after election, 2025. This is pure Nigerian practice for you. So we come appeal, and it's more so when we have enabling law. Court of appeal practice direction. Allow this matter to be had quickly. So we're a better place to be in court of appeal. So don't see it as if we're taking time, we're playing with time. It's something good that happened today. Because I can assure you 100% if you had proceeded today, the matter will not go on. These people are not ready to go on. They will file a further charge and serve before next adjourn day. Then when you come back on September, they will have a further charge. They will file probably another 7 count charge or 6 and serve us. And we'll start afresh. So these are compelling facts and document his lordship court of appeal. We're going to appeal against the ruling of today, of course. They have notified to the public. So his lordship has to look at it. And the court of appeal should look at it. You can't be talking about somebody's attempted murder on somebody. Then, and in the process, people were killed in premises, and we post to this additional affidavit. Look at it. Very compelling documents. How many paragraphs? How many pages? See it. Well detailed. See it. And the court didn't make any single pronouncement on it today. No pronouncement whatsoever. No reform was made to this document before the court. Filed since first day of April 2019. Are you telling me that they didn't see it? In fairness, this is what was filed before the court, and it was identified at the point of taking the application. It was identified before his lordship that it was filed on 1st of April. You can't move at this application without identifying that it was filed and dated. It's an elementary part of this practice. That when you are taking application before the court, you must identify the state the date was filed, state it was dated, and it was clearly stated in court record. So why are you telling me it was filed 4 years after? Thank you so much for
we should be by default 2 years. 2 years.
I don't know.
More or less.
What you say it took us almost 4 years to move this up.
Okay, Barrister, before we go, I just want to be in the know, following the stay of proceedings from the stable of Justice Binta Nyako and their version to the 3 headsmen in the appellate court. Does it happen to touch only the bail application or the counts in its entirety?
No, we're talking about what in the appeal that the one that has appealed has been entered. We're talking about a remaining 7 count charge, which are in all falls with the 8 count charge that we are struck out. They have the same facts, the same circumstance, the same drafting method, the same story. So you can't distinguish between the one that was struck out and the one that got left. So, and the grounds upon which they were being challenged, the entire thing count charge we are being challenged is the grounds upon which the remaining 7 returned by court also being challenged. So we are urging the court of appeal to also look beyond that and dispute the entire count charge. We have done it in some other cases, and we believe that that will get justice there too. We are going to appeal again this one too. For the sake of clarity, we understand that court of appeal that Federal High Court Umuahia has already ruled on civil application brought before the courts for fundamental right enforcement of our client, Mazi Nnamdi Kanu, for invasion of his premises and also the genocidal massacre of 28 persons in his premises. So, and the court found against the federal government that they grossly violated his fundamental right by the invasion and also killing, hearing, and made foul-reaching pronouncement, gave order for compensation and also for public apology. So, however, my lord, when that was brought to the attention of my lord's lordship, he said that he observed in open court when application for the bail was moved, that even when this application was moved, that the purport of the rule of the State High Court was to sit on appeal against her judgment. Like she's not binding by that judgment of the court. That's what they said. But it's a judgment of the court, and which the federal government has not been obeyed. It's a court set up by the government. No matter how stupid, as many call it stupid, the order of court is, we must obey that order. So as I speak to you, the federal government of Nigeria, heavily led by President Buhari, are in contempt of court judgment. They are in contempt of court order. Because court said gave them time within which to apologize. The court gave them time within which to pay compensation, and they've not done that. So, and that settles the issue of jumping bail. So, which is imprimatur with what we stated in the available support of this application.
Yes. More importantly, Barrister, speaking about bail application, because we understand that the main ingredient in the application, the bail application, is tilting towards health grounds of your client, Mazi Nnamdi Kanu. We just want to know, what is the latest development bothering his health now, because it is only one who is alive stands trial. How is he?
Well, the point that what I want to tell you at this point in time is that we have a situation in this case that is becoming overwhelming. And it's important for us to let the public know. We have had cause to file several shared contempt proceedings against the detention of facility, detention authority, and all those applications ends in this court. We have cause to file from 48. You know, when you're initiating contempt proceedings, you have to file from 48. Notice of consequence of the evidence to court order, and it was decided by the registrar of the court. And Federal High Court registrar here in Abuja told us point blank that you cannot sign it. Not to once, not twice. We are wasting our time. We should go back to court and resolve our problem. They cannot sign. So when court made an order, you cannot enforce it. You see our predicament. So what are we doing here? Order a court made in open court that Nnamdi Kanu is entitled to have a medical practitioner to re-examine him for second opinion. The court made an order about the changing of his clothing. We send them today. Even in open court, the court made an order, take it to detention facility, let him change it. Where are the clothes? People were there. It's not in open court.
Yes.
So we have a number of letter of orders this court has made. In fact, I even pity my lord. And I'm just making order in a vacuum. Nobody's obeying it. So these are predicament to find ourselves. So what are we doing? So we should be clapping that we are living there to court of appeal, because that's the most important thing.
Okay.
Believe me, I'm happy.
Yes.
Because it is possible that even the court will grant him bail today, they will not even leave him. Mark my word, it's possible that if the court has met more than 10 orders in the past and they cannot even obey one, then how are you sure that even the court, if the court has backdated this order, revoking his bail or issuing bail warrants against him, that they obey it? They will not obey it. So this is the point. So let's go there. Let's go there when we have 3 people. So they will review it. So let me see where court of appeal will make an order, then they will not obey it. So it's been on. So he's managing his house. He's understanding the predicament to find ourselves. We kept on encouraging him. Of course, we heard from him today. You know what's going on. We meet with him every Monday and Thursdays. But this face will come to pass. We were here when President Buhari granted press conference last week, granted the press interview. During his title during the bilateral meeting, Commonwealth head of state meeting. He categorically told the British Prime Minister that Nnamdi Kanu was sometime in the past granted bail. This is a matter before the court. Granted bail and he jumped bail. How are you sure that if he's granted bail again, he will not jump bail? Are you getting the language? Are you getting the statement?
And that is the executive.
Are you getting
towards the judiciary?
Are you getting? So let me just say this to you. Wish cried in the night, Abi?
Yes.
And the baby died in the morning.
Yes.
What will we say? What will be the analogy? I will end this on this note. Wish cried and the baby died in the morning. What will we say? I won't go further on this. There's a serious executive interference in what we are doing in this court. Simple. My Lord is helpless. The court is helpless. I won't go further on that. But I believe we are going to the upper court.
Yeah.
And I'll still continue to apply for CAM. Appeal for CAM. We need understanding and focus in line with admonition of Mazi Nnamdi Kanu today. Because we are getting there. Victory must come and must come soon. Let's continue to keep our eyes on the ball. Let us don't derail. That's what I'm telling you. Thank you for being here, and I wish you safe journey back to your various destinations, and God bless. So going back in
before you end, I just want you to throw more light in a layman's understanding everything about the pending appeal court. You know, people have been hearing about appeal court. What is it all about?
Okay, let me just come to a level that even the people at the market there will understand the language I'm using. These people filed 15 count charge against Mazi Nnamdi Kanu and the servers, and look at the charge and said this thing is not a charge. He didn't disclose any offense, and it didn't show that Nnamdi Kanu committed any offense from what we have, and also backed up by the law. We come to court and tell the court there is nothing here in this charge to warrant his further detention or even to warrant the trial to go on. The court's okay. That, and because of that, the court has not. We were saying the court. We told the court that you have, because there is nothing here in this document to warrant him being tried. That as such, you have no powers to try him. So leave him, let him go back to where he came from. The court's okay. Let me look at this document to file, and the court look at it and say, okay, Chief Ozekhome SIN, we have seen that. I agree with you that out of this 15 count charge, that 8 is not disclosed offense. It's true. I will strike them out, but 7, I will leave them. Now we go to court of appeal, and we are telling the court of appeal that there's no difference between the 8 left and the 7, and the 8 struck out and 7 left. That are the same thing. That the court of appeal should look at it and strike out the data. There's only 7. So now we will go. That's all. We won't struck out now. That's the end of the proceedings. No bail again. Nothing. We just go a free person. So is it clear to you for now? Yes. So that's what we're doing court of appeal now, and it's coming up on the 11th of October from here. And I said, as I said, it is better for us to be there. You who have been coming to court, you understand the trajectory of this case. You don't need to be no longer a lay person. You've been coming, all of you have been coming. If not because of this step we're taking now, the matter will be adjourned to October again, and October nothing will happen. You will adjourn again to this year. I hope you're getting what I'm saying. So let me understand that part. Because had it been the ruling was delivered on the merit today, we won't be talking about this. Today you'll be freed. But it's now clear to everybody that so thank you so much.
Yeah, thank you very much.
People are waiting for us. Yes. So, and it's compelling also, needful that you advise and also put through as to what's happening in court today. We are going to speak the English language for the benefit of those who are not understanding the Igbo language. So, because last time some people were actually asking questions, they are not understanding what you are speaking in Igbo language. So, of course, you know, this project cut across the Biafran nation and other places. Yes. So today the matter came up for ruling on application to vacate the order, revoking bail granted Mazi Nnamdi Kanu sometime in 2017. Then I know a portion to that revocation of his bail in 2017, a bench warrant was issued. So, however, we promptly filed an application to set aside in 2019. We promptly filed an application to set aside that order revoking his bail in the same 2019, and that application was filed on the first day of May, the first day of April 2019. Served on the prosecution, and they responded, and we also filed our reply on point of law. From that 2019 1st of April it was filed, stretched to 2022. We have repeatedly brought that to the attention of my lord, the court, that we have this application. Because this application sought in substance to explain to the court what led to the disappearance of Mazi Nnamdi Kanu, what happened in his place on 14th of September 2017, how the military invaded his premises, how 28 persons were murdered there in cold blood, how he narrowly escaped being killed. And more so is the fact that these are facts clearly verified on oath by Mazi Nnamdi Kanu when he was in Israel. So it's stated because it's the evidence of an eyewitness. He was there. He was the victim. So he stated clearly what transpired in his house, how he managed to escape. So, and this evidence and evidence is very compelling for the court to understand also. I give it a serious weight. But unfortunately today, the court delivered a ruling, and we understand that the court said that there was no application that was filed before her except this year. That we waited till 2022 to file an application to explain his whereabouts. We also, that has been addressed, but I understand that may be it's an error which is seriously wrong because the application was filed on 1st of April 2019. So it was filed promptly. And that application is very compelling. If it was given meritorious consideration, I believe that the ruling of today would have been different. Despite the fact that God said we can still come back to him, and also with further information and facts regarding to what happened in his house on September 14, 2017. However, we have gone on appeal. We are now before the Court of Appeal challenging the charge, challenging the return of the 7-count charge out of 15 by the court. So, and we followed it up to ensure the appeal was entered in good time, and also have an application, a motion to hear the appeal speedily. Of course, under the Court of Appeal fact direction, the appeal of first session is such which fall within classification of the appeal can be had speedily. And we also followed it up with an application for accelerated hearing, which has been which court has magnanimously given us 11th of October for hearing. It hasn't happened before. So, and we believe that from the look of things and from the position of things as it stands in this court today, that we'll get justice in the Court of Appeal. So obviously, because 3 heads better than 1. So we are trying on our appeal, including the one of the one of the final part of the ruling delivered today. We are going to also appeal against it too. So, however, and based on the persuasive argument of Nestle, who is valuing us, she was the court has still proceeding to the court on the matter. So the court will no longer, in general, should entertain this case again, pending determination of the matters, or the appeal will file before the court of appeal. So we have other serious applications or serious suits before the court, which will, one way or the other, determine the entire proceedings. And we have the view that when this appeal is heard, appeal also challenging the return of some count charge before this court, and when it's heard and determined, most positively, I can assure you that will be the end of the case. And now they can walk out. As you have heard him in court, we will continue to advocate for peaceful conduct and civility. And he continued to advocate. In fact, he was forced to say it out today, because we know that you people most times are being provocated, are being tried to go into certain activities that may probably lead to arrest, but we have to avoid it, because we know what you are passing through today. So our prayers for you is that you go back to your various destinations safely. And while you are traveling, you have to be very careful, because we have a lot of enemies now who are all over the places looking for who to devour, but it will not be your portion. And we are assuring you that we are not resting our oaths. All the lawyers in this case, bring this lesson. We are not resting to show that only Mazi Nnamdi Kanu is out, and he will be out soon. And it's total. Thank you so much for coming. May bless you exceedingly, and also grant you safe journey back to your various destinations. And men bless. Thank you so much.
Help us and pay Mazi Nnamdi Kanu. The Nigerian government did not release Mazi Nnamdi Kanu. This election will not. This Nigeria will not contain all of us.
I'll convert to you.
Prince is okay.
Prince.
Oh yeah.
Not even because I know that I'm victory is coming. Mazi Nnamdi Kanu has done nothing wrong, but he's fighting for the common folk. So it has to be free. So nobody should underestimate this. Biafrans. Well, what happened? There was a whole lot of arguments in the court. You and I know that the challenge, of course, the non-application made, and also the question of jurisdiction. So the defense team already proceed to appeal, and that is what is happening today. So in the next couple of weeks, you'll hear about other people. So definitely I understand what will come out. But we know here that we'll get justice here. And for this court, there will be justice. For the appeal court, there will be justice. And that's what I'm
So you think Nigeria is taking the case to appeal?
Yeah, of course, yeah, that's what we are. We've done that already. Yes, thank you so much.
So what do you see at the end of the day?
Of course, the Mazi Nnamdi Kanu must be free. Biafrans must be free.
We're still live at Federal High Court Abuja to get more updates on what happened today. So we are still waiting for our barrister to address.
I'm not saying that she left the prospect for a new application for bail open. Open a defense choice bring such an application forward. She's going to reconsider her bail. That's number one. Number two, based on the matter that is pending before the Court of Appeal, namely the challenge to the jurisdiction of the High Court to put Mazi to trial based on extraordinary rendition. That matter is pending on appeal before the Court of Appeal. The judge granted stay of further proceedings of the criminal case, pending determination of that question until before the Court of Appeal. So that is what happened in court today, and then the matter was adjourned to November 13th for mention. They will go na Court of Appeal, but I can assure you that between now and that 14th November, a lot of things will happen. In Abuja here, presumably by my colleagues, but I'm so sure of what I'm going to do. I'm going to do one thing so no matter.
Interview the special
afternoon. I want to know what is happening today. I understand that today is a trial of Ipob leader. So what is happening and what do you know so far that has happened today?
What happened today is the murder of in fact, today I saw the murdering of justice. I saw justice being murdered. I saw, in fact, today what I experienced today, I have not experienced it before. I have never experienced what I have experienced today before. I thought this country can work. I thought there is a way you can shape it to work, but I don't know that the country has become contained totally. That there's nothing you do in this country that will never work with it. That's what I saw today. Because from what I see today, the one I want to tell you is this. We came here, there was no exit, they blocked everywhere because the is coming from the streets. And because of that, everybody was stranded. Nobody can access the way to my camera. That's one. Secondly, I had a conversation between Buhari and Johnson that he said that he granted Nnamdi Kanu an interview and he granted Nnamdi Kanu bail. He granted bail. Sorry, it's not an interview. He granted bail, and because of the bail, and Nnamdi Kanu jumped bail. That there is possibility that if he grant another bail, that Nnamdi Kanu will jump it. You know, I thought maybe an ordinary talk, maybe a conversation. But what I understand in this country today is that one is one that decides what happened in this country, including justice part of it. Because the something you said is what I saw that happened inside the court. They denied Mazi Nnamdi Kanu bail. Because they say that they granted him bail and there is a possibility of him jumping bail. which we know on our own that Nnamdi Kanu never jumped bail. He has never jumped bail. A person that they came to kill in his house, how to run for his own life, that they say he jumped bail, and because of that, they did not listen to the bail application anymore. And I'm telling everybody that is saying Nigeria will work again, that obedience and other things. I'm telling everybody that there's nothing like that because the country you are into is already condemned, and there's nothing that will work in this country. I'm telling everybody, even if you bring an angel, you bring angel in this country.
Let's move. Yeah, thank you. All right.